Okay, so back to treaties. So a treaty is an international agreement. The president has the authority to enter into a treaty. Once the president does that, however, it has to go back to the Senate to be approved. The Constitution says on the advice and consent of the Senate. If the Senate does not approve the treaty, it does not become, it's not ratified, it's not binding. Now, why is this important? This is important because we're seeing more and more often as the world gets smaller in a way, we're seeing more and more globalized treaties like the World Trade Organization, the United Nations, the European Union, all the various different trade treaties that we have throughout the world, Central American Free Trade Agreement, for example. So we're seeing a lot more of these, especially in trade and commerce. So for example, here's one example for you, the WTO, World Trade Organization. You may know what the WTO does. It organizes world trade, right, WTO. Now, essentially the WTO is kind of like the United Nations of international business law. And it's the idea of shipping and all sorts of different laws involving international trade. And the idea is to standardize the laws of members of the WTO. So a treaty, which is the WTO, part of the WTO involves patents and trademarks, intellectual property, protection for inventions. So the WTO is a treaty. It came into existence in 1995. And as part of the World Trade Organization treaty, all states, all countries that were part of the WTO had to have their law provide 20 years of protection for a patent. A patent is protection for an invention, a design, a formulation, etc. So 20 years was the requirement under the treaty. Our law at the lower level at that time in the United States only gave 17 years. So our internal law was 17 years, but the treaty was 20. They conflict, right? So what did we have to do? We had to change our law to match the treaty, which is what happened. So it doesn't happen all the time, but we do see this where a treaty, that is the president entering into a treaty, and the treaty conflicts with the lower level law. So long as it's approved by the Senate, then what happens is we have to change our law to match the treaty. Now think about that for a minute. That, in essence, gives the president the ability to legislate through a treaty. And so that's why we have that check and balance that the Senate must approve, because in essence, the president, through a treaty, could enter into a treaty that would override a law passed by Congress. And so it's backdoor legislation, basically. And this was recognized when the Constitution was created, and the idea is, okay, well, we need the president to have the authority, but that needs to be a check or a balance by the Senate for separation of powers purposes. So you don't see it very often. I know it's kind of an esoteric example, but we'll probably start seeing that more and more often as we have more large-scale treaties in the world. Now, treaties are fascinating to me. I teach international law as well, so that's why I kind of harp on that. But it is something we're seeing, and I just want you to be aware of it. I won't get into the intricacies of it. What I want you to know is it's number 2 on our list. So if this is a royal flush, the U.S. Constitution, a treaty would be basically maybe 4 of a kind in our poker game that we're playing. Okay. Next, we have statutory law. I'll put a little star by it at both federal and state level. Okay? Statutory law, statutes at both the federal level and also at the state level, state statutory law. So first of all, what is a statute? It's not a piece of artwork, that's a statute. A statute is a law created by the legislature. Statutory law is law created by a legislature. Legislatures write statutes. I'm going to say it over and over again. So when Congress at the federal level or in the state writes a law, that typically is going to be what we call statutory or legislated law. And so I will ask you that on the test. What is a statute, or which branch of government creates statutes? Answer, legislature. Now the reason why I put a star there on both the federal and state is in your everyday life, statutes are probably the most important source of law for you and what you do on the everyday world. Because that's typically, if you're charged with a traffic violation, for example, maybe you're speeding or you don't stop at a stop sign. You don't stop at a stop sign or, oh, sorry, or whatever. You're charged with violating the law. Typically, you're going to be charged with violating a statute, a law written by the legislature. And so, in the real world, if you ever need to go research the law, the first place you should really look is to determine, is there a statute, a law written by the legislature, that covers or deals with the issue that you have to resolve from a legal standpoint. Because that's where most of the laws that govern our everyday business dealings, traffic, tax code, etc., are going to be found. At the federal level, we call statutes that are made by Congress the United States Code, right here. United States Code, USC or US Code. So when we refer to United States Code, when Congress sends a bill to the president approves of it, it becomes a law, that's a statute. And that then is written down, and now we call it United States Code. Typically when you see the word code, or Latin codex, is written law. And so US Code is federal statutory law. At the state level, right here, state statutory law. In Oregon, we refer to those as the Oregon Revised Statutes, otherwise abbreviated as the ORS. And so, if you walk around campus, you look at some of the signs that are going on, you'll probably come across one that says ORS, where is it? ORS, and then a number. Like for example, out in the parking lot, disabled parking, blue sign, which is created by law. The statute says you have to have a blue sign for disabled parking. It's ORS like 818 something. So statutory law is law created by the legislature. Again, probably your most important source of law for everyday living. Now, in the real world, if you do need to research a legal issue, I always recommend that you start by looking up the state where you are, the statute at the state level, because they match or they parallel federal law, typically. So in Oregon, we call it the ORS, the Oregon Revised Statutes. In Nevada, it's the NRS, the Nevada Revised Statutes. They may go by a different name. For example, in California, it's called California Code. In Washington, I think they call it statutes. I don't remember off the top of my head. But they go by different names. Code, statute, whatever. All I want you to know is statutory law is law that's written by the legislature. So let me show you what a statute looks like real quick. Page 12. Okay. This is an Oregon statute, so this would be an ORS. And this was a law that was then written by what body of government? This is Oregon. The Oregon Legislature, thank you. Okay, so this is remember civil and criminal from last class session? Anybody know if this is a civil or criminal law? Criminal, how do you know? it's assault, but it says right there, crime, right? We're going to learn later that there is also civil assault, and we'll get into that in a few weeks, okay? But for today, I don't want to get into those details. I just want you to see what the law looks like. So, a person commits the crime of assault in the second degree if the person, and there's different options here, number one, intentionally or knowingly, under letter A, causes serious physical injury to another person. So if I do that, to another, serious physical injury. So serious physical injury is permanent impairment. So for example, if I went up to somebody and I took my thumb and I gouged into their eyeball and pulled their eyeball out and threw it on the ground, that would be assault too. That's a Measure 11 offense, by the way, 70 months in the penitentiary. I actually had that case once where that happened. Letter B, an alternative way that you can commit this crime. If you intentionally or knowingly cause physical injury to another person by means of a deadly or dangerous weapon. So letter A and letter B, there's a difference. Letter A is serious physical injury, but no weapon. That's permanent impairment, but you didn't use a weapon. If you used a weapon, it would be assault 1, a higher level felony. Letter B is if you cause a lower level injury, just physical, not serious physical, but you do so with a deadly or dangerous weapon. And then finally, letter C, if you recklessly cause serious physical injury by means of deadly or dangerous weapon under circumstances manifesting extreme indifference. So that would be like discharging a firearm into, maybe I was out hunting and I see a bush or a tree move and I shoot at it, but I don't verify my target. Turns out it was a person, not a deer or whatever. And so that's reckless. So the first two are intentionally, you do it on purpose, or knowingly, you know what's going to happen. The bottom one is reckless. We'll talk more about that later. But for right now, I just want you to see what a statute looks like. So this is a law that was written by the Oregon legislature. So if you're accused of this crime, you would then go to a trial, and this is what would have to be proven in court. This is what the jury would have to agree on, that you committed that crime. And we would have to provide evidence to match that charge. Now, again, this is a statute. So if this law conflicted with the U.S. Constitution, which one would win? The U.S. Constitution. It always wins. It's the royal flush. This law does not conflict, well, depending on how it will be applied. Like I say, I used to be a prosecutor in Portland, and this was a very common crime that we would prosecute pretty commonly. All right. So statutory law is law written by a legislative body. This is an example of a statute. We're going to come back to that one in a few minutes, and we'll take a look in more detail at it in just a few minutes. So back to our sources of law page. All right. Next on our list, right up here, we have administrative rules. And both at the federal level and the state level. So, first of all, what is an administrative rule? As we've talked about already, at both the federal and state level, we have various different administrative agencies that have been created over time. And their job is to engage in enforcement activity and regulatory activity for whatever their jurisdiction is. So for example, at the state level, we have the Oregon Department of Fish and Wildlife, ODFW. Their job is to create rules that regulate fishing and hunting and those types of things. At the federal level, we have a whole number of agencies. We have the Federal Aviation Administration, the FAA. They write rules for airlines and safety regulations. We have Federal Trade Commission, Federal Bureau of Investigation, the FBI, the IRS, Internal Revenue Service, Department of Treasury, the Department of Commerce. We have all of these different agencies, Atomic Energy, et cetera. And what are their job? Their job is to regulate that particular sector. It may be business or taxes or fish and game or whatever the case may be, right? Sometimes we call them the alphabet agencies. And this is where we've seen a huge growth in law over the years. So the idea of an administrative rule is an agency has the ability to write rules that govern their particular area. And those rules, for example, environmental law, that governs how a factory or a manufacturing facility can discharge water into the sewer, has to be cleaned up, you have to have equipment, and that the administrative rules will detail what type of equipment, what the particular emission standards are going to be for discharging water into the sewer, and if you go above those standards, you may be in violation and subject to a fine. Or like in the airline industry, they have very detailed safety regulations for maintenance, log keeping. In trucking, I used to do a lot of trucking law. We have all sorts of administrative rules that deal with how many hours a driver can drive, how many hours they have to take off in between shifts. I have the same thing in the airline industry. We have safety regulations that are promoted by OSHA at both the federal and state level for construction contractors, having to wear a hard hat, a safety vest, and all that kind of stuff. So these are all administrative rules that are written by administrative agencies. So that's why I have E right here next to the administrative rule, executive branch. At the state level, we have a whole number of state administrative agencies, everything from the Oregon Department of Revenue to the Department of Motor Vehicles, to the Oregon State Bar that regulates lawyers, Oregon Fish and Wildlife. You guys have run into these, I'm sure. And so they all write rules about regulatory, regulating that sector of business. So the idea of an administrative rule is rules that are created by the agency based upon the area of law that they are charged with enforcing. Now I want you to think about something for a minute. So, how is it, let me back up. So some of these rules, for example, if you violate the rule, you may be subject to a monetary fine, or potentially criminal, but typically it's civil. That is only monetary or non-jail time as a penalty. So how is it, if these are rules written by the executive, how is it that those rules don't violate separation of powers? What do I mean by that? Which branch of government has the authority to make law? Legislative. Administrative agencies, for the most part, fall under the executive branch. The executive branch administrative agencies are now writing rules, which may include a fine, and these fines, like for airlines, they may be millions of dollars if you violate safety regulations. So how is it that the executive branch can write law, and guess who enforces the law that they wrote? They do, same agency. So how is it that that doesn't violate separation of powers? Do you know? Sometimes it does. If an agency writes a rule outside of their authority, it violates separation of powers. So just to cut to the chase, in order for an administrative rule, and this is true both at the federal level and the state level, in order for an administrative agency to be able to write a rule, the legislature first must write a statute that, number one, creates the agency, and number two, gives the agency the authority to write the rule. That's called enabling legislation. And so basically, for example, in fish and wildlife, the legislature doesn't really have the time to sit down and figure out, okay, how many salmon have run up the river as of this date, and we now need to shut down fishing. So the legislature doesn't really have time to count the number of salmon and figure all that out. So the legislature will write a rule that says, all right, Fish and Wildlife, you have the authority to write rules that regulate fishing, what kind of equipment you can use, how big the hooks can be, they have to be barbless, is it bait, or is it lures only, or fly fishing only, whatever, right? So we're going to give you, the legislature gives the Fish and Wildlife Division the authority to write rules that regulate fishing and hunting, and also to determine seasons for closure, or maybe bag limits, how many fish can you keep in a day or a week or a year, or whatever. And so they're delegating the authority from the legislature over to the particular agency. And that's true throughout all agencies. Airlines, very detailed regulations. Again, Congress doesn't really have the ability or the time to be able to bury down into all the technical details of a jet engine. And so they delegate that to the Federal Aviation Administration. Same thing with trucking and cruise ships and railroads and all of that. So the idea is that the legislature has essentially delegated this detailed rule writing over to the particular agency because they just don't have time for it. And then the agency also would be the one to enforce that law. So at the federal level, these administrative rules that are created by federal agencies are called the CFRs, the Code of Federal Regulations. CFR, right here. Code of Federal Regulation, abbreviated CFR. At the state level, we have Oregon Administrative Rules, OAR. Statutory law at the Oregon level is ORS, Oregon Revised Statutes, right here. Those are the laws written by the legislature. And then at the administrative level, we have the OARs, Oregon Administrative Rules. And these are the rules that are written by the various state of Oregon agencies detailing, like Fish and Wildlife, the area that they have enforced it, okay? So again, in business, this is really common. Most businesses are regulated now in some way, form, or fashion. Not all, but most businesses. So for example, if you're a restaurant, you have all sorts of health standards on how you store your food, how hot you cook your food, all those kind of things. If you're serving alcohol, you have to have serving permits and all of that. Those are all created and detailed in the administrative rules. And if you violate them, you can be subject to a fine or a cease and desist, and they shut down your restaurant or whatever the case may be. And again, as you walk around campus, a little game for you. See how many signs you can find that either are ORS or have OAR on the bottom of it. It's usually really small print right at the very bottom, right? It'll say ORS 811.112 or OAR, and it's usually a big long number. So that's the sign that says, prohibiting smoking, for example, within 25 feet. That's the administrative rule. You'll see that on the sign, perhaps. Now, what I want you to know out of this idea of administrative law, again, an administrative rule cannot violate the underlying statute. So if the statute sets a standard, a limit, whatever, and the administrative rule deviates from that, that violates separation of powers because it's the executive branch writing law. So an administrative rule can only be written within the authority given to them by the legislature. Now, why am I making such a big deal out of this? This is the trend in law and has been for 30 years and probably will continue. We are seeing more and more administrative rules being written every year. I mean, when I say number of pages, we're talking hundreds of thousands, if not millions, of administrative rules. And they're very, very detailed. And that's going to be the trend going forward, especially in business, where we're seeing these rules be the way that regulations on businesses and everyday life are more controlled by administrative agencies. So if you violate an administrative rule, you do have a right to a hearing, but typically it's not within a court. It's going to be in front of what's called an administrative law judge. So you don't have the same level of rights you would in a court. There's a lot of debate right now as how, in the legal community, you know, how much authority should be delegated to administrative agencies versus the legislature. Another issue is administrative agencies typically are not elected positions. They're appointed by within the department, whereas legislative bodies are elected positions. So, you know, on a political science level, there's some issues there on how far administrative rules can go before you're outside of a representative government. I won't get into that here, that's political science. What I want you guys to know from a business law standpoint is this is where nowadays it's more common that you'll find the very detailed regulations that you have to follow if you're operating a business. Again, I have a friend in the airline industry, and one of the things he says all the time is, what do the CFRs say? In other words, what do the code of federal regulations say? That's where you refer to determine what you have to do. All right, now, again, to recap, in the federal structure here, I have 4 sources of law highlighted in green: U.S. Constitution, treaty, statute, and finally administrative rule, in that order. I also have here the branch of government that creates those various sources of law, and I have put them in order. So the Constitution will beat all of them. A treaty will not beat the Constitution, but will override potentially a statute or an administrative rule. A statute will override the administrative rule, and then finally at the bottom we have administrative rules. Same thing at the state level. We have the state constitution, state statutes written by a state legislature, and then we have administrative rules written by the administrative agency within a state, in that order. I have several questions, depending on how I write the midterm, where I may ask you to put these 4 in proper order, or I will ask you which one beats out the others. Or I will ask you which branch of government writes that particular source of law. And so I want you to be able to say, okay, if I ask you which branch of government writes an administrative rule, answer executive branch. Which will be a higher source of law, an administrative rule, a statute, or a treaty? Treaty, okay? So I want you to be able to put them in order. Sometimes I do that as a fill-in-the-blank question. Name 4 sources of federal law and put them in proper order of authority, something like that. That's why this